Hello, hello. I'm going to start saying hello as people are joining us this afternoon. Hopefully, you're in the right place. It's Mental Health Reform's webinar on um, understanding the proposed changes to mental health law. Will have a short presentation and then a panel discussion. I'm going to be going through all of that with you. So this is set up as a webinar, so you'll only be able to see the people who are speaking. But the Q&A function is open, so please do put any questions that you like in the Q&A, and the brilliant Susanna is going to be monitoring that and getting that through to myself and the panelists for the second part of the presentation. So we're due to be here with you until 4, depending on the questions and the amount of questions and things like that that come in. We've 7 people on our panel, and we're very, very grateful to them for giving up their time here this afternoon. This is being recorded. So it will be available to watch back probably later next week or the week after on our website. So I'm going to, yeah, we have a lot of people registered. So I just see the numbers jumping up there. So I'm just going to give it another couple of minutes. And just to say, yes, so Susanna is keeping an eye on the Q&A box and will filter those questions through to us. We may not get to every question. I had asked for questions to be submitted to us by the end of last week, and I got loads of questions, but only asking if this was going to be recorded. So yes, it is going to be recorded, and it will be available on our website later. We had a webinar on the 5th of September, and that is the slide deck and the recording of that are available on the mentalhealthreform.ie website. So just as people are coming through, you're going to be muted. We're not having an raise hand open chat function. You can use the Q&A box to raise questions, and then we have questions for our panelists, and we'll be starting off with a short slide deck from myself just to kind of set the scene and tell you a little bit about who we are. We're calling it webinar 2 because on the 5th of September we had the first one, and on the 11th of November we'll be having an in-person seminar in Galway in NUIG. So if you're not already signed up to our newsletter or following us on socials, please do sign up there so that you can keep up to date with the events that we have between now and the end of the year. So just conscious of time. So there's still numbers jumping in there. We had over 900 people registered. So I was thinking if we had 300 that actually turn up, we'd be doing well. So the numbers are creeping up there. So I'm going to start moving on with the slides because we have a lot to get through. My name is Ber Grogan, by the way. Just talking at you all without introducing myself. I'm Ber Grogan. I'm the Policy and Research Manager here in Mental Health Reform. And as I mentioned, Susanna, our Policy and Advocacy Coordinator, is keeping an eye on the Q&A, and Stephen is also in the background for helping out with any tech issues. So hopefully everything goes fine. We already had a tech check with our lovely panelists. So I'll start going through some of these slides now. So we will be talking about things like involuntary detention. We will be talking about suicidal ideation and self-harm and everything that comes with mental health services and supports. So just to say at the start, whether you're working in the services, and this webinar is the main target audience is for people providing services. The one on the 5th of September was for people accessing services and family, friends, carers and supporters. So the tone might be slightly different, but it's really, really important for you to step away from this if you need to recognize, that it is a difficult role to be in, or it can be a triggering or upsetting thing to talk about and to think about, particularly because so many of us know someone who has been impacted by mental health difficulties, and may have needed inpatient treatment at some point. So I won't be offended at all if you need to step away. Text hello to 50808. Go on to our website and have a look at our membership. The HSE has a lot of resources as well. The yourmentalhealth.ie has been updated. So this is signposting, but it's also just a reminder that, none of us know what anyone else's experiences with mental health services and supports have been. So just to kind of be mindful of that, and to be kind and compassionate in how we're thinking about things. So our agenda today is, I have this short slide deck, and these will be shared on our website as well, later next week, or maybe early the week after. And then I'll come out of the slide deck and we will have a panel discussion with our 7 lovely panelists. So we have a broad range there of different services and service providers, and including academics and people who are members of Mental Health Reform and our coalition. And then we also have Tricia Keelty, the Director of Policy with the Ombudsman for Children's Office. And you'll see that we don't have any under 18s on our panel today, but we wanted to ensure that the voice of children are being included in this, because there is a whole new part 4 in the draft bill. So as I said, the Q&A function is open and available. I see it already popping up there. So the recording is in progress. The slides will be available. The information is correct as of today. And we say that because this is just a draft bill. Now, we all know an election is going to happen, so nothing else is going to happen with this piece of legislation until there is a new government in place. And even at that, we're probably going to have to do a bit of advocacy and lobbying to make sure it doesn't fall down the priority list. So this is the information that we have based off all of our own kind of readings of the draft bill, and everyone is probably coming at it from their own perspectives as well. But the main thing is there will be no changes overnight. There won't even be changes in 2025. And I'd say we'd be doing well if we have changes implemented and operational in 2026. So I think that's just the first thing to remember, is the bill will still have to go through committee stage, which is where amendments are tabled and discussed and voted on. And then it also has to go through the Seanad as well, where it gets debated, amendments get debated and then passed. And then it has to go to the president to get signed into law, and then it has to be commenced. So a good example in how long all of this does take is the Assisted Decision Making Capacity Act, which was actually passed in 2015, but only became operational in April, at the end of April last year, and that's because an amendment bill was needed for that. So really, no changes overnight. We'll see about the questions and things that are coming up, and we're going to talk a little bit about what we've been hearing from people as well. So we really want people to get involved. If you have canvassers knocking on the doors, or you have opportunities to go to hustings and discussions ahead of the general election, ask your candidates, what are they going to do about mental health services? Do they even know about the mental health bill? And this is where hopefully will be useful to you as well. We've loads of resources on our website. If you haven't heard of us, and just to say that we've been blown away by the interest in this webinar series. And I think part of the thanks, or a lot of the thanks, has to go to our friends in the HSE's National Office for Human Rights and Equality Policy, because Jacqueline and Caoimhe and Elaine and Sandra in the office have been absolutely brilliant, and they've shared information about these webinars among their networks. So you may have heard about it through them. We're the national leading coalition on mental health, and we're a small but mighty team, and we work on the kind of the legislative pieces, the national policy pieces, research, advocacy, pre-budget campaigns and things like that. So our vision is of an Ireland with accessible, effective and inclusive mental health services and supports. Our strategic plan is available on our website if you want to have a look at it. And as I said, we have coordination of our members, policy development. So we have 86 member organisations at the moment. So even if you hadn't heard of us before, you'll definitely have heard of some of our members. So the likes of Jigsaw, Pieta, the ISPCC, Bernardo's, Samaritans, A Lust for Life, Hug, the Irish Association of Social Workers, the Psychological Society of Ireland, art therapists. There's again a broad range of members that come together under the mental health reform umbrella. And even though they may work in kind of specific areas, so for example, like Bodywise or Shine, we all work together on the national and international level changes that we need for improved mental health services and supports. So to set the scene, we've been talking about the Mental Health Act and the need to reform. It's why we were set up when after the 2001 Act came into force, which I think was actually in 2006. So that's just giving you again that idea. Keep that in mind. Nothing's going to happen overnight. And it's a key piece of our work, and we have lots of different materials on. We have a specific web page for the hashtag Reform MHA. And we've done a lot of work on it over the years. But there's also been all of these other things happening across mental health services and supports. And some of the things that have been raised to us since the introduction of that there's been more talk about the mental health bill has been questions that could technically be referred back to the national consent policy. So there is a HSE consent policy which must be followed. There is a new Assisted Decision Making Capacity Act that I said it's been operational since April 2023, and that act has put into law the right to have you presumed to have capacity. So it's moving away from a presumption of not having capacity to people need to be presumed to have capacity. Their will and preferences need to be respected. There's a decision support service, and different levels of decision making assistance and representatives can be put in place with the person's consent if they wish. So that's between the consent policy and the Decision Making Capacity Act, there's already a huge basis there for including people in their treatment and in their care and having them as equal and active participants in the care that you have. The 16 and 17-year-olds, we'll talk about this again in the panel discussion, but there is already the Non-Fatal Offences Against the Person Act, which is where 16 and 17-year-olds have a legal right to consent to medical and dental treatment. So it has been an anomaly that mental health care has been left out of that. So we will talk about that a little bit more. The expert review group reported in 2015. A lot of the recommendations that were taken on for the draft HEDSA bill came from that expert review group. And we have the resource Talk to Your TD. And this is why I'm really pleading with you that when canvassers or whoever it is are coming to your door to say, what about the mental health bill? Like, we're so far behind international standards since we ratified the UN Convention on the Rights of Persons with Disabilities. It was a very progressive piece of legislation for its time. But it is outdated, and it has been something that we've been promised reform for a long time. And it was great that it was past second stage in the Dáil, but you know, there is a chance that it will be pushed down the priority list again. So our information is there, and that's where we're going to be posting the slide deck and the recording. So Susanna very kindly pulled this timeline together as well for us, because another thing we've been hearing is some people kind of saying that they're you know, they didn't get a chance to have a say, and this has kind of come out of the blue, and people have, you know, felt a bit shocked, and, you know, they're concerned, or they're not sure about some of the proposed changes, or some people think like that change is going to happen overnight. And if you take one thing away from this webinar, it's that nothing is going to change overnight. There will be a lead-in period, but also this is the culmination of a very, very long review and consultation process. So at each of these points, the department review, the expert review group, the pre-legislative scrutiny, people did put in their own submissions to those consultations and did make their own representation. So depending on what area you work in mental health services, there has been ample opportunity to have voices heard. So you'll see it was the reform of the Mental Health Act was included in the programme for government in 2020, and we did have the draft heads of bill in July 2021. We did some work around that at the time. Now, some of the draft bill does differ in some places to the heads of bill that we saw in 2021, but it has taken that long for the department, with its back and forth with the Attorney General's office and the Office of Parliamentary Counsel, to get us to the point now where we have a bill. And we know that there are government amendments needed, in particular for through children, equality, disability, integration and youth, and justice. So it's not a fully complete bill, but it did go through the pre-legislative scrutiny that started in November 2021. In October 2021, we commissioned a human rights analysis on the draft heads of bill, and that human rights analysis has informed our advocacy and our work on the draft bill. That was authored by Dr. Charles O'Mahony in Galway, and the late but brilliant Dr. Fiona Morrissey. And I think of her often now when we're having these conversations and moving forward on the Act. The pre-legislative scrutiny was still going ahead in April 2022, and then in October there was the Subcommittee on Mental Health produced a report with 19 recommendations. Again, not all of those recommendations are included or were included in the final draft bill that we've seen. We were doing a bit of lobbying, you know, kind of asking the chief whip and the government to, you know, please schedule it, you know, what's happening, it's taken too long, it's, you know, and kind of you'd hear every so often, oh yeah, it's really important for us, but it just kept kind of falling down the priority list. So it was finally published on the 31st of July 2024, which thankfully meant we had the summer to kind of to get to grips with things, and everyone had time to read through it and to start asking questions. And then in September, on the first day, the Dáil was back actually, which again we were very grateful for, because it's something we've asked for a lot. And it's nice when you actually feel like, yes, they are listening to us and they have heard us on this. So Minister Butler spoke on the bill, and a number of opposition deputies and government deputies spoke on the bill on the 18th and 19th of September. And what was really great was there is cross-party support for the bill. Everyone agrees that change is needed. Everyone did say, you know, that they want to work together at committee stage for amendments. But it was a really, really positive discussion around the need for human rights compliant and human rights based mental health legislation. So it did pass second stage in the Dáil, and it was referred to committee stage, but now it's sitting in that limbo in the moment at the moment. And just on that, on the Dáil process, basically when the Dáil is dissolved for a general election, all of the bills that haven't progressed, they fall with the Dáil. So we will be asking in the programme for government for the next government to reinstate the bill at the stage it's at. So to bring it back at committee stage, and then let's all discuss the amendments that are needed at committee stage. And then it will take probably most of next year to work its way through committee, Dáil, Seanad, get to the president to be signed into law, and then will still have to be commenced after that. So in the meantime, we just wanted to flag two of the resources that we have. So we did a toolkit with UCC. and that's available on our website at the moment. And that's based on your rights at the moment under the Mental Health Act 2001. And that is the piece of legislation that will remain in force until the new bill becomes an act and is commenced. So again, coming back to the no changes overnight, it's still the Mental Health Act 2001 that is governing inpatient treatment for people, for involuntary people receiving care. We did do a plain English summary, a NALA approved plain English summary of the key changes in the bill. Obviously, you can imagine it was a very difficult task to try and synopsize everything into plain English. So it's the key changes and key points, and it doesn't get into the legalities because, again, the final act will be different. We know some parts will look different, and we don't want to say nothing that's in the bill at the moment is law. So we didn't want to put anything out there that people might think that that's what their legal rights are at the moment. So they're both available on our website. Mammoth bill, 7 parts, 202 sections. Like, we're not over exaggerating when we say what a huge piece of work this has been. And we do know that there's been a huge amount of work done by the department in going back and forth with the Attorney General's office, the Office of Parliamentary Counsel, and the Minister and the departments on all of the work that has to be done. And we're very grateful for that work. And we do hope that because so much has gone into it already and so much consultation up to this point, that when we do get it to committee stage, we're all more or less on the same pages with a lot of things. So they're the 7 parts. You'll see there's a whole new part 4 which deals with everything for under 18s. So in some of them it's 16 and 17-year-olds, then it's under 16-year-olds, 16, 17-year-olds, where their capacity might be in question. So all of those different sections. So it's nearly like a piece of legislation within the legislation. And summary of the proposed changes then are that it's, instead of talking about a patient, we're talking about a person. There are guiding principles in the law, which is really important. And again, it's coming back to that idea of, the person's will and preferences, their consent, their capacity, what they want for their treatment and how they want to be involved in all of that, including care plans and things like that. There's the regulation, including community services. We know that that's been a big thing, and particularly since some of the CAMHS and MASCI reports that the Mental Health Commission have wanted to be able to regulate community CAMHS as well. So that all comes into it. There's closer alignment to the Assisted Decision Making Capacity Act. There's a right to have a nominated person. So it doesn't say advocate, but a nominated person. So that can be for you. It could be your mom or dad or best friend or partner, spouse, sister, whatever it is. And the information has to be in a form and language that the person understands, which we really welcomed those kind of provisions within the bill. It's really important. The parent or guardian will have a right to information of a general nature on the care and treatment of the child. So again, that's in if there are concerns around, well, my child isn't going to want me to know, there is a right to information around maybe the diagnosis or the mental health difficulties that the person is experiencing. Discharge planning has to take place. The involuntary detention, so there's some change around the categories for involuntary detention. People who can make applications for involuntary admissions, the Gardaí, even though they make over 1/3 of over 30% of the applications at the moment, they're going to be taken out of that equation, and it's going to be authorised officers, family members, and then anyone with a bona fide interest in the person. There's a new part relating to children, as we said. And the other really welcome thing is the psychosocial assessment. So when people are going up in front of the tribunals, are changing to review boards, you have a right to have a psychosocial assessment. So again, seeing the person in a much more holistic view around their supports, community supports, housing, whether they have addiction issues, all of those kind of things, rather than just talking about a mental health difficulty. So we've a couple of things. we're delighted about the guiding principles, the language changes, about the expansion of the regulatory remit, and the idea that you have a right to have a nominated person with you, or to access information on your behalf. There are things that we need clarification on, or that we'll be looking for amendments on, and that's the prohibition of admitting children into adult psychiatric units, which is what the UN Committee on the Rights of the Child have told us to do. We want to see an independent complaints mechanism, and we would like there to be a statutory right to independent advocacy. So we would like the nominated person piece to go further, to say that you have a right to independent advocacy. And we just, at this point, we just want the bill prioritised in a new programme for government, like, you know, and for it to be scheduled. We need it to be picked up where it's at and progressed. It could fall down the priority list. That is a danger, and that's what we don't want to happen. So this is the photo of our lovely panel. So as I said, we've seven of us. So what I'm going to do is I'm going to stop sharing, and we're going to have everyone on the screen at the same time. I'm going to then, we'll have questions for everyone, and I've seen that there have been some questions coming in on Q&A, so we can check in with Susanna on that. So I'm going to stop sharing, and everyone should, you see, everyone's faces are popping up there now. They can turn on. Yes, Brody's giving us a wave and everything. So thank you so much, everyone. And I had said I probably won't need until 3 o'clock, but sure, of course, this is what happens. Give me a slide deck and a topic that I really care about, and you know, I'm going to keep talking. So the format for this now is we have questions that we've been discussing, and things like that that have been coming up for all of us in our various ways of work. I see someone is trying to raise your hand. You can put questions into the Q&A box, and we're not having the kind of the open discussion, but you can put questions into the Q&A box. But first, to start us off, I'm going to welcome Brodie Thompson, the Sea Change Ambassador. Thank you so much. And I know Brodie had said hopefully her internet is okay and it won't drop off, but if she disappears, we'll have her back with us before the panel is over. So Brodie, I'm going to ask you to set the scene for us. And just talk a little bit about how important human rights and mental health law is for people who are accessing treatment.
Yeah, absolutely. Like I suppose, talk from the perspective of having my own lived experience of being unwell. And, you know, I'm here today as a volunteer, and I work as a volunteer for Sea Change and Shine. And it's just to give, you know, the voice, because so often as well, like I want to be the voice that I guess I wished I'd heard when I had been unwell, whether that was when I was a child, you know, really unwell with bulimia, or, you know, into my teens, 20s, and then even my 30s, where I've had a stint in hospital. And you'll hear more about from Shine, from the CEO later on. Nicola's on the call too. But, you know, I think you can feel so isolated when, you know, you're mentally unwell. Like if you go into hospital for, you know, any kind of physical ailment, everyone rallies around you. Whereas when you go in for mental health, it's kind of like everyone disappears and goes silent. And, you know, we're definitely getting so much better at talking about mental health and mental health difficulties and everything. But when it actually comes to, you know, it being, you know, in front of you or someone you know, that, you know, it's still confronting for people. And it's still, you know, in that space of, you know, do we actually, you know, like I know that we're definitely moving in a space of it being accepted and stuff. But I think a huge thing as well is that, you know, we always want to fix everything, but it's taking that time to listen. And I think, you know, one of the big things that I found with my time in hospital as well was that when I was first admitted, you know, a mental health professional sat down and listened to me. They didn't try and, you know, they literally just listened to me. And it was amazing to see the difference that made as well, just to know that, you know, someone was, you know, willing to listen attentively and, you know, not try and put labels and things and treat me as the person that I was and not treat me as just a patient. Because I feel like so often, you know, you can get dehumanized, and, you know, especially if you're in a group setting or something as well, that, you know, you're just kind of seen as the group of people that are unwell, as opposed to, you know, actually, everyone's got their own individual story. Everyone's got their own, there's so many different things that impact our mental health as well. And I think when you're in that space, you're so vulnerable. It's that point of actually, knowing that you need to ask for help, but also, or sometimes it's not even asking for help, that you just need help. But, to acknowledge that you're unwell, I think quite often, it gets forgotten about how difficult that actually is. That's a massive hurdle to overcome, to, acknowledge that you're not okay. And, when you're then dehumanized, or, not seen as the person in hospital, you're seen as a patient, that it then makes that so much harder to deal with. And it then leads to that, self-stigma and everything as well, that, not only are you experiencing the stigma from everyone around you, that, you go into hospital and all of a sudden everyone disappears, but then also as well that, your thoughts of how you think of yourself, and, you then get stuck in a headspace of thinking that, recovery is not possible for me. And it makes it harder to recover because, you feel like everyone's changed how they think about you, and you're thought of as, a patient that, whereas like if we think of, a patient with any, physical health ailment, we always usually think of, recovery as possible, that they'll have a stint in hospital and come out, whereas it can be a little bit more difficult to overcome that. And I think, from my perspective as well, I was unwell, I was in hospital, and then I'm back, but it was really hard then returning to work and everything as well. That was really hard for me to overcome because, I was so worried about, it's also what everyone thinks about, there's a big thing about when people think about people in hospital and, like, goodness, you actually told people you were in hospital, and it's such a, like, there's, even from family and stuff as well, that it's seen as an embarrassing thing, whereas it's not embarrassing. It's not something to hide away, and you're not just a patient, you are a person. And, it's like eliminating, those words and things around things as well. And, the importance of humanizing individuals that need, help, and having the person at the center of everything. Everyone wants different things. It's like that, everyone has different things that help them. And, I think choice is very important. And, I think it's, I was sick, but I got better. And, I felt like when I was, I suppose, treated in my most recent experience as well, that I felt like I was, a human being, as opposed to a patient. And I think that makes a real difference. So, yeah.
That's brilliant, Brody. And I think one of the things you said right there at the start was the difference between, a physical health condition and the mental health, and self-stigma is something that I'm hearing all the time now. Um, but I think we're always going to have self-stigma until we do break down those barriers around the wider societal stigma. And when you said about going back to work, like if it was, excuse me, a physical health thing, you'd be coming back to probably flowers and cake and like a celebration. And it should be the same for any time, that a person needs off. Work is such a big part of us. So a difference for you was really how you were treated by the teams, by the people providing the services.
Yeah, and I suppose you come across so many different people within those teams that are providing you support too. And the ones that really stand out and make a difference are the ones that, see you as you, saw me as Brody, didn't see me as, another patient.
Yeah, or a diagnostic label, or
Yeah.
yeah, because I think that's the other thing that we see, and with the psychosocial assessments and things like that, is two people can be experiencing the same mental health difficulty, but if you have a really supportive community and family network at home, or secure housing, or access to work, your experience of that mental health difficulty will be very different, if you don't have those supports around you. And so how long have you been involved in Shine now, in Sea Change, as the ambassador?
So I'm in my fourth year being an ambassador, so volunteer. So I'm actually, I have a pretty demanding full-time job. I work for an events agency, so I'm actually sat on the side of O'Connell Street at the moment in a van. There's big Halloween celebrations there this weekend, but yeah, so I've been a volunteer ambassador. So, I use my lunch breaks I use my weekends and, after work to, to talk and, to be that voice that I wish that I'd heard, because you do feel so isolated and you think, you're the only person in the world that's feeling as horrendous and unwell as you are.
Yeah, thank you so much. And we so appreciate you taking the time out of your busy schedule and the calls that you and I had as well. So, no, we really do. And actually, the webinar we had on the 5th of September, we purposely had it in the evening so that people would be able to attend after their work responsibilities. So I'll give you give your voice a rest, Brodie, and I'll come on to Trisha from the Ombudsman for Children's office, sorry, OCO's office. So Trisha, thank you so much for joining us here today. And I know, as I said earlier, we don't have any under 18s on the call, so you have the lovely job of being the voice of under 18s. Sorry, there's a lot of hopping around the screen there, but I think I see this is just to make sure everyone's awake, just paying attention now. So Trisha, I'll hand over to you. If you just could give us an overview of what the OCO's office are thinking about the bill, the work that you've done on it, and kind of maybe the work that you see coming into it.
Thanks so much, Ber, and thanks a million for the opportunity to speak to everyone today in relation to the bill from a children's rights perspective. And thanks so much for Brodie for that introduction. It really sets the scene really well in terms of what we're talking about and the impact this piece of legislation can have. I suppose it would be good just to ground ourselves in kind of the voices of children and young people. As we don't have under 18s here today, I thought it would be good to just maybe reflect on some of the consultations the OCO have done with young people who have received care for mental health difficulties. So if we look back to 2018, we did a consultation with young people receiving inpatient care and treatment for their mental health. And a lot of what they told us at the time was the really positives in terms of support they received from professionals and family members and other young people in receipt of mental health services. But there were significant challenges that they experienced. And a lot of it was in relation to how they were communicated with. So many questioned, medical professions, how they engage with the use of clinical language, confusion for some people, which left them feeling not believed or understood. And I suppose at the same time, they also felt like there was a lack of opportunity to be heard as they raised this as a significant challenge, both when they're inpatient, but also wider services as well. And a lot of the time, children and young people felt that their parents were being communicated with as opposed to young people themselves. And this kind of came through as well when we did another piece of work in 2002 and 2022 and 2023, Pieces of Us. So this was a children's report led by our youth advisory panel to the UN Committee on the Rights of the Child. And one child who took part in this consultation said, "I went there when I was 14, but I was on the waiting list for almost a year and a half. And then when I got there, they listened to my parents more than they listened to me." So from our point of view, the bill is really welcome. We have an entire section now dedicated to children and young people, and it reflects some of those child rights issues in terms of working in the best interest of children, also that their voices must be heard while it's not as strong as we'd like it to be in relation to that. We also really welcome the provision to allow young people aged 16 and 17 to consent to their treatment. This is in line with children's rights frameworks that recognise 16-year-olds have the maturity and capacity to make decisions affecting their care, and it's just bringing us in line with physical healthcare as well. And we also really welcome the provision to regulate community CAMHS as well. We've engaged with the bill from the general scheme when that was published, and we've been highlighting a number of concerns and areas where we think it could be strengthened from a children's rights point of view. I suppose just going to that guiding principle about respecting the voice of children. At the moment, it's not as strong as it could be in relation to the Convention on the Rights of the Child and also recommendations made by the UNCRC in relation to this piece. At the moment, it says children's voices must be considered where practical, and we're saying that should be deleted. It should really be strengthened from that point of view, that it must be a way of consulting with children as part of their care plan in a way that's meaningful. We do think there needs to be greater clarity in terms of how this will be done. So who will assess and determine whether a child is capable of forming their own views and how this is implemented in practice. And it's also silent in relation to what measures can be taken to ensure that due weight is given to children's views, particularly in regard to their admission. On admission to adult facilities, which Burr highlighted as one of the key areas that mental health reform want to see clarified, is also one for us. At the moment, the bill does have a guiding principle that children should be cared for and treated in age-appropriate environments, but it says insofar as is practical as well. So we need to see that that is an outright ban, and again, that will be in line with the recommendation from the UNCRC in relation to this. Again, similar to the mental health reform, we want to see a statutory right to independent advocacy. It has been weakened from the general scheme into the bill at the moment. So it was an advocate, now we have a nominated person, we need clarity around that. And it limits this right to children aged 16 and older. So all children should have access to an independent advocacy support. Similarly, in relation to legal representation, we think this should be strengthened, and in relation to the guardian ad litem, it reads now at the moment that it's up to the discretion of the court, and this is a really important area that we need to see strengthened. And then finally, on the issue of resources, again, the language here is not in line with international children's rights standards. Children are entitled to the highest standard of mental health care, even when resources are scarce. So we would like to see the language changed in relation to that, to ensure that children have that progressive right realised when the state uses the maximum extent of available resources. So I think more broadly for us, it's really important that this legislation is considered from all these aspects, but also, you know, the OCO has been very clear that we do need to increase funding to mental health services, that we do ring fence funding for children's mental health services, and that we look to multi-annual funding as well so that we can plan services effectively. I'll leave it there. I'm really looking forward to hearing the other panelists, and I'm happy to answer any questions. Thanks so much.
Thanks so much, Tricia. And you actually, you touched on some of the questions that were coming in there as well. So sorry, now, this is why I asked everyone to send their questions by the 18th of October. But sure, anyway, we now have the Q&A going and we have the WhatsApp going and everything. So please be patient with us. And I see Brendan and Susanna are flat out trying to respond to people as well. But just the piece about children not being admitted to adult psychiatric units. So says, is there no clear stance on this in the new bill? And if so, is this due to a lack of alternative option or resource? And I suppose what we would say is the 2001 Act is the law is silent on it at the moment. The heads of bill included a provision, so in July 2021, and a lot of us fought for that to be removed. But instead of putting an explicit prohibition, it's just taken it out. So the law is silent. Now, services are moving towards, you know, it's happening less and less. But what we would say at Mental Health Reform is we can't make law based on a lack of resources. You know, there has to be that legal right there for everyone. So I don't think there's any other questions here for you at the moment, Tricia. There's a couple of people have asked about the rationale for Gardaí, removing Gardaí as a group that can make an application for involuntary detention. But I think that comes back to, like, if you look at the report of the review group as well, you know, if you're in a mental health crisis, you're not told to present to your local Garda station, you're told to present to your local A&E or to go to your GP. So why would the guards be involved unless there's any sort of you know, alleged offence or anything like that, you know? So it's health. It shouldn't be part of the criminal justice thing. And the expert group actually said that only authorized officers should be the ones that could make the involuntary admissions, but some family members wanted to retain that right. So actually, I'm going to jump around a little bit and I'm going to come to Nicola on that one. So Nicola, I know in Shine you have family members as well as people with lived experience, and then family members with lived experience. And this has been a thing about not having consensus across family members maybe wanting to still be able to fill in the forms for involuntary admission, or some saying that they would prefer for authorised officers to do it. So what is Shine thinking about that, and is the best way forward just trying to listen to everyone, or what are you guys thinking about that?
Thanks, Bear. Well, Shine has been going since the 1970s, and it was set up by a group of family members of people with lived experience. And we work directly with people with lived experience, but also separately with family members and supporters of those that are experiencing mental illness. We do a lot of work in different arenas to improve recovery rates, and some of that is around our stigma reduction programs, the likes of which Brodie is what I described the magic dust in removing stigma. She's one of our Sea Change ambassadors. And we've just recently completed the Green Ribbon campaign for this year, which was our biggest campaign. And we also do work in the media around our headline programme. We would promote and work with broadcasters and journalists around responsible reporting on mental health, mental illness and suicide. As part of this work in preparing for the development of new mental health legislation, we consulted out to people that use our services, and we asked a lot of questions in addressing all the different areas under the heads of bill. And it's interesting, you know, the blue lights is something that we are really keen to have a conversation about. I'm around a long time working in mental health, and I remember conversations before the last Mental Health Act was enacted, and when it was a draft bill. And I remember meeting with the Gardaí. I'm a social worker by background, and the Gardaí never wanted the role. The previous Mental Health Act fell foul of the Child Care Act. So the Child Care Act, at the time that was developed in the and put into legislation in the 90s, overused the difference between the words may and shall in this draft is very, very important. And in the Child Care Act, the word shall was used in relation to certain services, and it cost the state a lot of money. And I think the Mental Health Act at the time then had more shalls than, or more mays than shalls. And so, you know, it is important that we look at those issues and why things develop the way they do. But before we went into, and we were grateful to go into the Dáil subcommittee in recent years and present, what we did was we presented results of surveys and consultations that we had, and we presented what we described as testimonies and statements from people. And so just to give you an example, when you're talking about the involvement of family members in mental health, and we asked the question about involuntary detentions, here's two different answers. One person said, no, I don't think that family members should have authority over other adults. Once you're an adult, you should no longer be under the power of your family, and you should be an autonomous individual. And then a different member of our Voice platform said, yes, I would prefer to still have the ability to sign in a loved one for involuntary detention, as this is very important for the well-being of a loved one when they do not have an insight into their illness, and it can expose themselves to harm if not signed in. I suppose the messaging in that is it's about choice, and it's about the relationships we have, and that we should not end up feeling that we have to go to a crisis situation where we have to involve the Gardaí. And this legislation the bill is to be welcomed because of the fact that it does really, at the end of all of this, what you want is respect and common sense. And that's what Brodie speaks to, keeping the person at the centre of it. And if we take a human rights approach to all of these, the thoughts and the thinking behind it, and the guiding principles in this bill is very important, because it does take that approach and it builds in and is aligned to the Assistant Decision-Making Capacity Act. And so we need to look at the ideas that not only are the concepts important, but the investment is at the end of the day. So the likes of the authorised officer, most people, when you consult with them, never knew there was the option to have an authorised officer. It was never invested in. It was never grown as an adequate service. So the public in general felt like, if I'm in a crisis, I'm really worried about someone, my options seem to be the GP or 999. And this bill provides the opportunity to adequately invest in a support that would mean that we don't have to resort to a police car outside somebody's door. So I think it's all about choice, options, relationships and respect. But from our perspective, issues like restrictive practice and addressing those things. Looking at a person from a psychosocial perspective is also key in how we can see the individuals and meet their needs adequately. And also to look at the issue of the advocate, people having an advocate. That's something that we've talked about, and there's been an underinvestment in that as well. So none of these concepts are worth their weight, you know, they're not worth salt if there's not investment going behind it. So I'd be pushing for, you know, that we do look at what is definitely an important measure, and that there's no get out clauses in the way that the bill goes into the next stages. But overall, you know, from Shine's perspective, it's just really important that we see that people are at the center of this, and that you or I in the morning may need the services. We may need to be admitted, and we may need to that may need to happen involuntary. And so we need to make sure that that whatever legislation is brought into place, that is future-proof for all of us. I see right now there's 432 people on this, and you know, I know that there's other people watching, but really we're talking about legislation that can and will impact all of us. And so it's really important that we see it in that way. It's really good, having served on the Mental Health Commission, it's really vital that the regulatory remit of the Mental Health Commission is extended. In fact, you know, the Act and the role of the Mental Health Commission to date has been very limited. And the benefit of having good regulation, good oversight, and conversations that extend the sight and the way that we look at our services and the quality that we demand for them is so important. So overall, everything that's come to date, there is tweaks that I would like to make, but from the people that use our services, it's really important to say that this bill is long overdue to be brought to the next, and I would welcome that when that it forms the next programme for government. But you know, and it's just, if we always take it back to where does this legislation impact all of us? And in the morning, we could, all of us, fall foul of any of the measures that we're drafting right now, you know?
Yeah, and I think it's a really good point. And I'm going to bring on Brendan and Mary now just to talk a little bit about the Assisted Decision Making Capacity Act and the pieces around capacity and consent, because there are some of the questions that are coming in, people talking about, you know, if someone is found to not have capacity. So myself and Brendan and Mary have done a couple of the rounds of webinars while talking about the actual Assisted Decision Making Capacity Law. So Mary, I might come to you first, just around that piece around if someone's capacity is in question, what are kind of the first steps that service providers should take?
Well, I suppose the most important thing to say is that the Assisted Decision Making Capacity Act applies to anybody who's in an approved centre, and is only disapplied for a very small number of people in a very small number of circumstances. So that's the first thing to be really aware of, and sometimes people don't realise that. And the first thing that has to happen under the Assisted Decision Making Capacity Act is there's a set of guiding principles, and the person has to be supported to make their own decision. So that's the place we start from. They can choose a supporter themselves if they consider that their capacity is in question or may shortly be in question. They can choose their own supporter, but there is an obligation on service providers to support them as well. Now there is a limit in that, in the sense it's as far as practicable, but it's an absolute obligation under the Act. So one of the most important things which applies is, and of course I should say there's a presumption of capacity. So if you're anybody, what's called a relevant person under the Act, you're presumed to have capacity, and that's an absolute presumption that applies to absolutely everyone in absolutely every circumstance. There's no disapplying of that. So you presume capacity and you support. So before we get into assessing capacity, you're operating on the basis of a presumption of capacity and a requirement to support. Maybe I'll hand over to Brendan if he wants to pick up from there.
No, I think you've covered the key points there. The bill as it currently stands, it does create a rather complex structure when someone becomes admitted without consent and treated without consent. But part of that in the bill as it stands is that there should be presumption of capacity, support given to the person to make their own decisions. And in the event that that is not sufficient, then an application to the Circuit Court for decision-making supports under the capacity legislation. There was a question there about links between the Mental Health Act and the Capacity Act. That is quite a complex question as matters stand, yet more complex with the bill. But nonetheless, there are efforts being made to sort of merge the two. And I know the Mental Health Commission is doing very good work to try and sort of bring more coherence to the system for sure. I guess more generally regarding the 2024 bill, it is probably worth noting that it does not include any measures to improve the level of mental health services. It does not provide a single euro more or any kind of additional resource for services whatsoever. That is not what it set out to do, and it duly does not do that. So other jurisdictions have taken different approaches here. They have used legislation to try and bolster a right to services, but that is not the approach that has been taken in this bill, which does not contain any measures to better resource services, unfortunately. And I guess that is a partial response to a number of the questions we've seen there in the chat.
Thanks so much, Brendan. And I just realized I had my thing set on speaker view, which is why whoever was speaking at me was only pinned. So now I see all of you there. I'm going to come quickly to Fran as well, because there was also a question about family peer support work. So Fran, can you tell us a little bit about your role and how, as a family peer support worker, you interact with mental health legislation?
Thanks, Ber. And just to say, I'm delighted to be part of the panel today, simply because family peer support is a relatively new role in Ireland. And as it stands, there is only 10 family peer support workers dotted across the country. And well, hopefully there is an agreement with Recovery and Engagement that new roles will be coming on stream in the future for peer. So it's great to see that the role is developing. And just to go back to the beginning with family peer support, after the Mental Health Vision for Change government policy in 2006, we're looking at a more person-centred approach and a more fully family-related kind of care for people using our services. There was a lot of evidence to show that members of the family, or if they're supported alongside the person that's experiencing mental health challenges, that there's a better opportunity for a whole family recovery. And I always go back to the professionals in terms of quoting things like that, and even the Royal College of Psychiatry of Ireland quoted that in the Recovery Resource Guide document with Refocus, I think that was 2020. So yeah, as I said, it's a relatively new well, it's not a discipline yet role. It began in May 2015, and the role at the time was supervised by the HSE and employed by Shine, and later on by Mental Health Ireland. And in 2020, the role was integrated into the HSE, which was great to see, because it does show a change around recovery and a change around a better societal support approach to people using the services who are unwell. It's a lived experience role. So my role right now, as I sit here today, is coming from lived experiences, which means I have supported a loved one for many years who had a mental health challenge, which is ongoing. So on top of me bringing my lived experience, that's how the role has progressed. I'd also say that in 2016, I used the services of the Family Peer Support Service myself. It was previously known as Ballochnew at the time, and having come through the services, I saw the value in the role itself and how important it was to me, how important it was for my own recovery and acceptance of the changes that had occurred in my life. And I stayed on and used part of my recovery to be involved in voluntary organisations like Shine, as Nicola had mentioned earlier, and did a lot of voluntary work, which helped me And when these roles came up, I jumped at the chance to do it. And I hope that that's one of the things that helps me support family members by empowering them and providing some level of hope for them. We also sit outside the MDT teams, which supports confidentiality, and that goes both ways as well. So we're not influenced by the team, and the team, we're not aware of what treatment is going on, and anything that's discussed between myself and the family peer, it's not carried back to the team. So there's total confidentiality between the two. We really focus on the family members' own self-care. So the role isn't so much about coming in to teach you how to better support your loved one or the person who's unwell, although sometimes that can be part of it. Our role is really to support the family member around their own self-care, because again, studies would show that other family members, when they're doing well, their loved one will do better as well. So we'd empower our family members to advocate for themselves. So we're not advocates ourselves, but we would encourage them to advocate. Families also feel just that having somebody who understands where they're coming from, it's good for them to talk, and we're not trying to fix them. We're not shocked or surprised at anything that they say. We quite literally provide a safe space for them to talk about their emotions or how they're feeling, or the impact that the mental health crisis has had on their lives. We also help them to navigate the mental health system, because none of us are professionals, and when a mental health crisis comes into your home, you don't automatically know everything and become a professional and knowledgeable about everything involved in it. So we'd advise and navigate around it, and there's always a constant conversation around consent, or why I'm not part of my loved one's care and treatment. So it's basically to try and even explain to them the rationale for it, why it is, it should be the person who's unwell and that they should be at the centre of it, but that the family, so that there would be a level of confidentiality, and once they understand how those things work, they tend to just feel a little bit more comfortable and settled in what their expectations are, and if they're not included, why they're not included. Equally, if they're not included when they should be, if consent is available, that they understand the level of inclusion that they're allowed to. So with this bill, we're all, I think, talking around the same topics that are common around advocacy and around consent and authorised officer. I think it's the same things that's coming up. Family peers, it might only be a tiny cog in the process, and only, shall we say, a part of it, and maybe the person using the services is the bigger area, and that's the centre of their recovery. But from a family perspective, it's the same conversations that we're having. So I'm delighted to see certain things that are improving that will have a positive impact on the families as well.
Thank you so much, Fran. And I'm really sorry because something happened to my internet and I got kicked out, and then I came back in and I panicked. So apologies. But at least I came back and you were still chatting, so it was grand. And just to say that Brodie just sent me a message. She had to get back into the office, but we're very grateful to her for being with us today. Owen, I'm going to come to you next. I think it fits in really well with what we're talking about around family involvement and kind of confidentiality and consent around sharing information. Will you talk to us a little bit about, as someone providing, a social worker providing CAMHS services, how is that working for you, and what kind of things are coming up for you?
Yeah, well, I suppose it's the bill actually strengthens some of the work around family involvement, and I do family therapy myself as well, so it's obviously a priority for social workers. But I think one thing is just to kind of clarify where we're at the moment, because with the HC consent policy, some of these things actually did change quite a bit, because the age of consent for mental health treatment in the community goes to 16 and 17. With the family, and that was based on the non-fatal, that part, an interpretation of that. But that also has the impact of the family involvement is actually weaker at present than it will be with the bill. So I think some of the concern people have, actually the bill strengthens that aspect of the, you know, we really see family involvement as being very important. And the other part of it is information, how people access information. So at present, you know, a parent has a right to information under freedom of information. They can request to see the information in the file. And then that has to be balanced with the best interests of the child and the privacy of the child, which is quite a complex balancing act there. So I think this the suggestion within the bill will actually broaden the information and broaden the emphasis that family information and the family being involved in care planning is actually much better embedded in this bill than it is at present in the current circumstances. And I think let's just keep in mind, I think if people need clarity on that, I would certainly recommend reading the current consent policy, which is in place there since 2022. And then the other part of it is that the emphasis on psychosocial assessments is very welcome. You know, if you look at mental health difficulties and mental health disorders and the systemic piece of it, you know, the family, the life around the person, I think that emphasis is very welcome as well. It certainly would involve families a lot more. And then another point, the final point I'd make around family involvement is a point Brenda made, which is the bill doesn't actually create any new services or any new right to services. And those words of insofar as practical make a big difference. So one of the concerns I think a lot of say social workers, maybe in some of the inpatient units, people working in child and adolescent inpatient units around the country would have, is that sometimes families are traveling maybe 200 or 300 kilometers into the inpatient unit, which is, you know, it's very hard for a family to be involved in the care of their child if they're traveling these huge distances. And at the end of the day, when the person leaves the facility, they're going to end up going back to their family. You know, in the main, obviously there's exceptions to that. Mostly they'll go back to their family or the care environment they were in. And it's very hard for families to be involved if they're that far away. But what the bill says is that insofar as practical, the care will be provided in close proximity to the family home or the carer's home. But really, I think that's a bit of a question, because, you know, if you live in the top of Donegal or the bottom of Kerry, your only inpatient unit is Galway, as my understanding. So it's a huge distance, you know, regardless of what the bill says. And there's no, as Brendan said, there's no requirement in the bill for services to be provided. So there's quite a bit in it as regards family involvement. I certainly would encourage people to, you know, read through it. Anybody working in CAMHS particularly, to kind of, you know, see how it will actually impact on their role in the future.
Thanks so much, Owen. And I think that's the big thing for me with the bill and us needing the best kind of legislative rights as possible, the best piece of legislation as possible, is while the bill itself doesn't provide additional resources, it puts an obligation on the state to provide. It means then we have a legal right to the things in the Act. So we know, like, the Mental Health Commission is going to need significant increased resources with its increased regulation capacity. And just to say, I saw Orla Keane was putting in a couple of questions and comments there, and I believe the Mental Health Commission will be doing some sort of webinar or session later in November. And I think IREC, the Irish Human Rights Equality Office, will as well, and the Irish Council for Civil Liberties. So there's a lot of kind of other agencies linking in with this and spending a lot of time really reviewing it. But that's one of the things for me, is it puts an obligation on the state to provide. We have a legal right to how we're treated. And someone actually did mention about the kind of the recruitment crisis and embargo. And again, it's completely unacceptable that people are expected to work in under-resourced, overstretched places. Like, that's not going to be a good place to work. It's not going to be a good place for people to receive care and treatment. So all of those things are reasons why mental health reform has been, you know, acting and calling for so long for improved legalities. Just on that, the wording around insofar as practicable, Mary, if I can come to you as one of our legal experts, why does the government throw things like that into their pieces of legislation and their bills?
Wiggle room, really. you know, it's and wiggle room is not always a bad thing, but it can be a bad thing, but that's it basically. It's to allow the government to avoid committing resources to something. Well, in some circumstances. In other circumstances, it might be because there would genuinely be, so it's not a resource related issue, but it might be that something might be very difficult. So for example, if you're talking about will and preference and ascertaining a person's will and preference, it's very important that you take, you know, steps to ascertain somebody's will and preference. Let's imagine they lack capacity. Let's imagine in the context of mental health, they're having a particularly challenging time. There is a limit to what can be done in some circumstances, just literally that it's not possible, because you are trying to balance resources within a situation. What's really, really important is that, as far as practicable, isn't a get out clause. So it's not, sometimes it's treated as it can be treated as a get out clause, as in, oh, it's as far as practicable, and oh gee, it wasn't practicable here. So it isn't a get out clause, and it shouldn't be treated as a get out clause. Interestingly, there's very limited court analysis, judicial analysis of what constitutes as far as practicable, which is why things like codes of practice become very important in circumstances like this. Codes of practice and guidance. So for example, if you think of the Assisted Decision Making Capacity Act, we've got, I think it's, 13 codes of practice, not all of them relevant to health professions, but you've got one on health professionals. So they are a place where you can set out what constitutes practicable. And then they have a bit of bite. So they mean that it's not a get out clause. So I do think that it's very important that I don't think it's unreasonable that we sometimes have as far as practicable in a headline piece of legislation, but I do think we need, at a kind of regulatory or at a service provision level, to dig into that and actually give people guidance on what is or isn't practicable, what's reasonable, what can actually be done, and that it doesn't become a get out card. Thanks, Bert.
Thanks so much, Mary. I think it's really, you know, when like you work in this and we read all of the pieces, I think it's useful for us to have that wider conversation. And actually on the codes of practice, I do remember with the assisted decision making capacity codes, there were consultation processes. So just Nicola, just very briefly, I wanted to come to you again about the importance of involving the voices of lived experience in consultation processes and how we can best do that.
I think involving the voice of people with lived experience is essential. It's key. All of the international evidence and research shows that you get better services, you get more increased recovery, and you know, ultimately you keep more people alive in a better quality of life when you involve the voice of people lived experience. But that's at all levels. That's when you're designing the legislation, when you're designing the building, and right then through to care planning. And, you know, I keep bringing it back to the idea of common sense and respect. And it's where we started at the start, that the statement about everything being person-centered. If you keep the person at the center, you can't go wrong. And every problem we've had with, you know, services failing, people becoming unwell, it's often when the person is left out of the center and they're not included in the conversation or the planning. And so, you know, we've just, in our services, we've developed an organized way to putting the voice of people with lived experience at different levels. But international research shows that the best cure for stigma in this country or any country is people hearing the voice of people with lived experience. Full stop. There has been acres written on it. And so if we can get that into all of our principles and the way we approach things, we will be guaranteed better outcomes. And going back to issues like the care planning and the way we've developed this in this country, it's essential that we always keep the person at the center. And that will mean that we will develop adequate care plans, respectful care plans, but they actually will be the right plan for the right situation. But I also think it's really important that we, you know, there's there's a lot of people on this call, and it's probably, I always say these webinars have the wrong people at the webinar. It's the people who are interested and bought into these things. And, you know, for family members, it's key that they are seen as opportunities for collateral. Sometimes that's not even respected in services, but also they're partners in service delivery. And they are primary care. You know, we've had an underinvestment in primary care, but at the end of the day, when somebody, and I use the phrase family member loosely because often you're not the biological or the legal family member, you're more likely to be in the description of supporter. But we need to be thinking about, you know, listening to those that at the end of the day are at the center of moving on from the admission, moving on to successful living. And we find, you know, that people's voices and their representation wax and wane as life gets better and you get busier and you go on to work. You're less likely to have the opportunity. Look at Brody in the side of a van having a conversation. It gets harder as life gets your quality of life goes up to be able to contribute to these things. But in the round, you know, it's very simple. Putting the evidence is there to say, putting the voice of people with lived experience at the center of everything guarantees better outcomes.
Thank you so much. And to add to that, technically, it's our right as well under the UN Convention on the Persons of Disabilities. So if you have enduring mental health difficulties that are impacting your life, technically they are psychosocial disabilities, which means you have rights under our Equal Status Acts, our disability legislation, and under the UN CRPD. So Article 4.3 in particular, if I have any of our disabled advocates online as well listening, I don't want to forget pointing that out. So it is the state and its agencies do have an obligation to consult with people with disabilities around policy changes. And I'm sorry, I know I feel I'm distracted because I'm trying to look at all of the bits and pieces that are coming through. I just saw, and thanks so much, Brendan, as well. You're getting some of the questions directed straight to you. There was a research piece that we did on mental health services in prisons, and you can look on our website for that. And a couple of people are asking again around the Assisted Decision Making Capacity Act and the consent policy. And what I would say is there's a huge amount of resources out there. This is a snippet piece on the mental health bill, you know, so you will need to go and have a look at the Decision Support Service website at assisteddecisionmaking.ie. There's a huge amount of training already available on HSE land. And one of the things is that over 60% or around 60% of people who are involuntary admitted each year are readmitted into our mental health services. So in mental health reform, we're advocating for people to talk about their will and preferences and to make advanced healthcare directives. And before I do kind of a last round of questions, I want to go back to you, Brendan, because I'd love for us to talk a little bit about and I see a lot of questions have come in about, you know, if you're worried about a loved one or if someone is very unwell or doesn't have capacity, how can we move towards a mental health service and system where the majority, and I know the majority are at the moment receiving treatment voluntarily, but what do you see the pathway to kind of that, you know, ideal scenario?
Yes, indeed, Ber, thanks. I mean, it is important to recognise that the vast majority of mental health care is delivered in the community on an entirely voluntary basis. Ireland's rate of inpatient admission is exceptionally low. We have the third lowest number of psychiatry beds in the EU. Our rate of involuntary admission is extraordinarily low. At a given moment in time, we have about 330 people who are involuntary patients, or at least they're being admitted without consent. Some of them are passively accepting it. So internationally, a very low rate as matters stand. A lot of my colleagues on this call working really hard in the community to deliver care in the most non-restrictive way possible. It is worth noting maybe that in the bill, the criteria for admission and treatment without consent probably do need revision, maybe to de-emphasize risk particularly and focus on treatment. And also there's a question there about capacity and involuntary care. the bill does need revision, that if people are admitted without consent, the mechanism it proposes for treatment is bewilderingly unwieldy. It's suggesting that anyone who is, as we say, involuntarily admitted would have mental health tribunals, and I know the Commission does a great job at those at the moment, but would also at the same time have a circuit court process to assess capacity, and if they refuse treatment, would also have a third legal tier happening all at the same time, with the High Court issuing treatment orders. It is a grave concern to think that any person in such a crisis would be subjected to 3 tiers of legal proceedings at the same time, when in fact it should all just be handled by 1 tier of legal proceedings. Obviously, the best way, if it is possible to reduce our rates of involuntary admission even further, the best way is of course emphasising community services, voluntary services in the community, psychiatric care, psychological support, social support. You know, we know that even with conditions, say like schizophrenia, the lack of social support hugely amplifies the disability associated with these conditions. It magnifies the problems. So better, earlier, linked up mental health, social support and addiction services. Keeping these things in separate silos is toxic for people who need these services. So if we are to reduce the rates of admission and treatment without consent even further, it is at that level that we need some pretty serious input. And also, of course, further downstream, some revisions to the bill in terms of criteria and mechanisms for treatment.
Thanks so much, Brendan. And I think it's a really interesting point where we've talked a bit about resources and kind of political priorities. And sometimes we'll see maybe like the CAMHS, South Kerry CAMHS report, and something like that kind of gets media attention, and then it gets political attention, and then the focus will go on CAMHS beds. Whereas again, instead of looking at the early intervention and prevention pieces, and we're doing a piece of work with the London School of Economics, we know it's the morally right thing to invest in our mental health services, but we're also trying to get that piece of evidence for the incoming government and the civil servants to show that it's also what economically makes sense. You know, we're trying to talk to the government in those kind of terms, because we know that most mental health difficulties can present in under 18s, you know, but CAMHS should actually only be for like 2% for a very small number of people who might need specialist services, and that other young people should be able to get access to early intervention and prevention, you know, the no wrong door referral process. And we know that there is work happening in that at the moment with the new Children and Youth Mental Health Office. And just to acknowledge, I think as well, it can be really important for us to focus on everything that needs to be done. I think it's important to acknowledge that there has been quite a lot of progress and things happening, particularly in the children and youth mental health area. Things take time to bed in, and we do want to make sure people with lived experience and children are being heard. So I'm going to do a quick kind of roundtable of like just a minute sum up of, you know, either the most welcome change or what's the main thing that you would like our lovely attendees to go off and think about. So Brendan, I'm going to come to you first.
Well, focusing on the bill, there are some good changes to definitions and other specific aspects to it. I think it needs a lot of revision in certain other areas, particularly regarding admission and treatment without consent. But in terms of take-home messages for everybody attending, you know, we do need people to advocate with politicians for better services earlier for everyone, and also to bear in mind the magnitude of the regulation of people's lives. So, for example, we know at any moment there are around 330 people detained in psychiatric hospitals or being treated without consent. But this is regulated already. It could be improved on, but really the Capacity Act and does need to be amended or changed slightly as well to provide greater protections for the 27,000 people in nursing homes, for where practices are generally very good, but they do need greater regulation, possibly through amendments to the Capacity Act. And I would like to see the bill rely a little more on the mental health tribunal system for involuntary patients, because the Mental Health Commission does such a great job with those.
Thanks, Brendan. Mary, I'll come to you next.
Uh,
Oh.
Thanks, Fer. Sorry. So in terms of good things, there are definitely good things. I would obviously, and I think all of us would love to see resources and some kinds of actual positive rights in there. Take your point though, Ber, that sometimes by establishing certain things, perhaps it will push resources in the right direction, but and that is a disappointment. Or the absence of independent of access to advocacy is something that's missing. Having said that, the fact of the appointment of a nominated person is better than nothing, so let's be glad of that. Also very glad to see that we're coming towards clarity of the position regarding children and young people and age from 16 on. Owen quite correctly says that the national consent policy since 2022 is very clear that a child aged a young person aged 16 can consent to mental health treatment, and that's something I don't think people are always aware of. Not under the Mental Health Act. The Mental Health Act uses the but very few children are admitted under the Mental Health Act. We're talking about tiny numbers. So so that is something that's there in the national consent policy, just to remind people of that. We are seeing the beginnings of the knitting together with the Assisted Decision Making Capacity Act, but there's a lot more work needed there and a lot more care needed. Now, to be fair to the Department of Health, the 2015 Act, the Capacity Act, leaves a lot of things unresolved. So it's actually very hard to knit in with something when it's not doing everything the way we would wish. So I would like to see some more work there. Just to call out the fact that the 2015 Act also applies to people from 18 up in general, or at least it's not clear. So that leaves a gap for those 16 and 17-year-olds that we need to address. And just also to reiterate Brendan's point, this business of having 3 different sets of legal bodies involved in treatment decisions and admission decisions, it's wasteful, but it's also not the best way to protect human rights. There's a recent court case, really literally the last week or so, which has come out, HSE versus HH, and the judge there is very, very clear that courts are not. They're really important as appeal mechanisms, but they're not the best way to protect human rights. You need to have mechanisms that work on the ground to protect human rights. So I think we really do need to enhance our protections. Sorry, going on too long. Thanks, Barb.
No, that's great, Mary. And the thing that always pops into my head then is like the social determinants of health and people having secure housing and community and all of that kind of stuff. Nicola, very briefly, what's your takeaway from today?
I think, it's the whole bill, and it's disappointing that we're going to be going into an election. But the positives are, at long last, we're embedding a human rights perspective into our legislation in this area. My big thing is it needs investment. Investment is needed, especially with the likes of authorised officers and that. And really at the core of everything is if we can keep the voice of people with lived experience at the centre of all of the work we're doing. And that is key when we look at the bill and having a person-centred approach. I would like more work done on the issue of advocacy, again, like similar to the rest of the panel. But at the end of the day, going back to my 2 quotes from the 2 different supporters, we are complex people with complex needs, and it's to develop a service and a system that deals with all of those needs well and good. But it's just long overdue.
Yeah, thanks so much, Nicola. Owen, I'm going to come to you next.
Yeah, just a couple of things on it. One, I would say that it's a very welcome change to have that focus on human rights. And I also think when when we look at the lifespan of people's experience with mental health services, it's good to have a similar experience from, say 16, for example, to 22, where your opinion, your input is respected throughout, because it is in a way an arbitrary line, that 18. And the other point I would make is that when people read these kind of changes, sometimes there's kind of a natural fear of it, and people can think of the worst scenario. And if you take the idea that hard cases make bad law, well then hypothetical hard cases make even worse law. And
Mm.
actually, the position I would suggest to people is to think about what way you would like services to work if they were in the best scenario, which would be listening to people, responding to their needs, trying to get your family involved and working with them. That would be the best services. And rather than having that fear-based approach of this is the risk, this is the terrible case that might happen somewhere, to go from that approach first. And also, we're lucky to live in a democracy, you know, and anybody that's on this webinar, I'm sure people, you know, would listen to the people that are listening into this webinar. They're that interested in it, you know, so you do have a say in this as well.
Yeah, and I think it's saying that about the best possible services as well, but it's put yourself in the shoes of the person who needs the services, and how do you want to be treated, and how do you want to be communicated with and supported. And I think empathy, you know, if you're coming from a place of empathy, then you're you know, it's hard to go wrong. Fran, I'm going to come to you, and then I'll give our under 18s the final say before I go out to my last couple of slides. So Fran.
Thanks. And yeah, probably singing along the same lines as everybody else here today. I'm really delighted to see that we're moving into a meaningful move to a person-centered approach, and putting the patient using the services at the centre of their own recovery, which is really important. I'm glad to see that there's legislation being put in place to help this, because it will only stay as an essence if it's not legislated for us to have the support from government and the backing from government. So things like, and I know I'm talking about person-centered approach for the person themselves, but as a family member or carer or supporter, you're always the person on the sideline when things are good and when things are bad. So I'd welcome, when things are good, having the opportunity to have an advanced healthcare directive. It's great to have the opportunity to sit down when you're in a good headspace, and to be able to write down what your wants and your wishes and your needs are. And unfortunately, I suppose I would have been looking at, I'm delighted to see the nominated person. I don't think it goes far enough in terms of advocacy, but to have a nominated person, that they can bring them, that there's no kind of ambiguity around consent, because I think sometimes when we're talking about consent, we really are coming from a place of risk, as opposed to, or you know, it's how we deliver the formulation of risk. Are we telling people, this is, who do you consent to be part of your care and your planning, and who would you like to have part of it, as opposed to going, do you consent to this? So I think it's about changing the narrative on it as well. And probably the biggest thing, which is maybe a bit, everyone, well, Nicola and myself, I would say exactly the same as her, that we have family members that would say the authorised officer is a good thing, and I would have family members that would say the opposite as well, that it's not so good and they want the choice. But the thing with that, I suppose, is regardless of who makes the phone call, it is going to be the psychiatrist that makes the decision at the end as to whether the person is detained or not. From my own personal perspective and dealing with families, they have welcomed it, and they have felt that it takes them out of the picture. They find that when they're the person that's ringing for somebody to come, and that they're being blamed for the negative things that happen through the experience, and that the outcome of that is that their relationship with their loved one can become very fractured. On the other side as well, I just like the fact that the authorised officers are trained, and they understand the whole mental health system. I would agree on the blue lights syndrome. I've had family members say that to me. Again, it's not a crime, and the guards would still be there if there was need for their assistance stepping back from it. An authorised officer can also, it's very much person-centred if they sit down with that person and have a just down-to-earth conversation with them. Obviously having a checklist to go through, but they're having a conversation around what are your needs, how are you feeling, and where are you at now? And they can also advise them, and maybe nearly make an oral agreement with them to make sure that they're going to check in with their teams going forward. Equally, we're talking about acute units here, and the majority of time people who are unwell, they're in acute units for a very tiny period of time, and after that they're coming home, they're coming back into society, they're coming back into the community. I'd like to see more supports around that, and even just as quickly as them being discharged, they're being discharged home to families who are not equipped, and they're like auxiliary staff, and they really do not have the training or the understanding. So from again, consent perspective, there should really, I'd like to see more done in discharge planning to include families, so that we're able to support our loved ones when they come home to us.
Thanks so much, Fran. And just, I know we're going a couple of minutes over, but if people will just bear with us for a second. So on the webinar we had on the 5th of September, the recording of that is available on our website. And we did have an authorised officer speaking on that panel, and she talked through kind of the process of getting in touch with authorised officers. So Tricia.
Thanks so much, Ber. I think I said most of what we welcome in terms of the bill at the start, but just to really emphasise that just like any adult or anyone else, children and young people want to be heard in terms of their care. And I think this bill really has the potential to change how we approach that in relation to children and young people. And I think in relation to how their views are included and considered, there is some thinking to do about that in terms of practice and guidance and training, but it's really a very positive development that this is a right now for children, and I think that's really, really important. And just to say, from our point of view, this piece of legislation can't fall, and it has to be part of the next programme for government, and we do need further discussion, but it's really important that it's pushed on. Thanks.
Thank you so much. And again, if people just hold on with me for 2 seconds, or maybe 1 minute. So there you go. Next steps. We're going to be continuing this work in 2025. We need your help, all of you, whoever, if you're working in services, you're providing services, wherever you are, your voters, your constituents, which means you have a voice and candidates will listen to you. New programme for government, first 100 days in government. We want this to be at committee stages, and delighted that the resources came up so much. And as I said, we're going to be in Galway in NUIG for an in-person seminar on the bill on Monday, the 11th of November. So look out for our socials. We have some resources here. These slides are going to be available on our website. So there's loads of resources there. We'll be sharing them. Please sign up to our newsletter if you haven't already, and follow us on socials to see the work that we're doing and to keep up to date on the webinars, the plain English summary, you know, the videos that we have around assisted decision making around the UN CRPD. We've loads of resources on our website. So the best way to kind of keep up to date on what we're doing is following us on socials and sign up to the newsletter. And I'm just going to finish off by saying a huge thank you to our panel. Like, honestly, I know you're all so busy, and I really appreciate it so much. So Tricia, Owen, Brendan, Fran, Mary, Nicola, Brody's gone already. A huge thank you to Stephen, who's been in the background, and a special huge thank you to Susanna, who was answering, I think there was over 40 questions and comments that came in at one point. So they're working away in the background, and obviously and reading through lines of legislation as well to put these pieces together. So thank you very much. We'll see you all very soon, and hopefully some of you are based in Galway and you'll come and see us in Galway. Thank you so much, everyone. Oh, we will be doing a questions document after all of this as well. We'll make that resource available on our website as well. So thank you very much, everyone.